H1B is not dual intent visa. H1B is non-immigrant visa. You are correct that there is no law explicitly stating that H1B visa holders cannot have dual intent. However, the Immigration and Nationality Act (INA) does state that non-immigrants must maintain a foreign residence and have no intention of abandoning that residence when they enter the United States. In practice, U.S. consular officers and immigration officers have the discretion to deny H1B visas to applicants who they believe have dual intent. This is because H1B visas are non-immigrant visas, and non-immigrants are not supposed to have the intention of immigrating to the United States permanently. There are a number of factors that U.S. consular officers and immigration officers may consider when assessing an applicant's dual intent, including whether the applicant has a job or business in their home country, whether the applicant has close family members living in their home country, whether the applicant owns property in their home country, whether the applicant has financial assets in their home country, whether the applicant has applied for a green card or permanent residency. If a U.S. consular officer or immigration officer believes that an H1B visa applicant has dual intent, they may deny the applicant's visa application. It is important to note that the doctrine of dual intent is not absolute. There have been cases where H1B visa holders with dual intent have been able to successfully immigrate to the United States permanently. However, it is important to be aware of the risks associated with dual intent and to take steps to minimize those risks. For example, H1B visa holders with dual intent should avoid taking any actions that could be interpreted as evidence of an intent to immigrate to the United States permanently, such as applying for a green card or permanent residency. Maintain strong ties to their home country, such as by having a job or business in their home country, having close family members living in their home country, and owning property in their home country. Be prepared to answer questions about their dual intent during visa interviews and immigration proceedings. The Immigration and Nationality Act (INA) defines an H1B visa as a non-immigrant visa that allows U.S. employers to temporarily employ foreign workers in specialty occupations. The law defines a specialty occupation as an occupation that requires a theoretical and practical application of a body of specialized knowledge and a bachelor's degree or its equivalent as a minimum entry requirement. To be eligible for an H1B visa, a foreign worker must have a job offer from a U.S. employer and must meet the specific educational and experience requirements for the specialty occupation in which they will be employed. The U.S. employer must also file a petition with the U.S. Citizenship and Immigration Services (USCIS) on behalf of the foreign worker. If the petition is approved, the foreign worker will be able to apply for an H1B visa at a U.S. embassy or consulate. H1B visas are initially valid for 3 years, but can be extended for an additional 3 years. H1B visa holders may also be eligible to apply for permanent residency in the United States. Here are some of the benefits of having an H1B visa. H1B visa holders are allowed to live and work in the United States temporarily. H1B visa holders may be eligible to apply for permanent residency in the United States. H1B visa holders are allowed to bring their spouses and children to the United States on dependent visas. H1B visa holders are allowed to travel outside of the United States and return to work as long as their visas are valid. The term dual intent was first used in the context of immigration law in the 1960s. At the time, the Immigration and Nationality Act (INA) did not explicitly state whether or not non-immigrants could have the intention of immigrating to the United States permanently. However, the INA did state that non-immigrants must maintain a foreign residence and have no intention of abandoning that residence when they enter the United States. In the 1960s, the U.S. State Department began to use the term dual intent to describe the situation where a non-immigrant had the intention of both maintaining their non-immigrant status in the United States and immigrating to the United States permanently. The State Department argued that dual intent was inconsistent with the INA's requirement that non-immigrants maintain a foreign residence and have no intention of abandoning that residence. In the 1970s, the Supreme Court of the United States ruled in the case of matter of form Hortan that non-immigrants could have dual intent. The court reasoned that the INA's requirement that non-immigrants maintain a foreign residence and have no intention of abandoning that residence was not absolute. The court also reasoned that there were many reasons why a non-immigrant might want to maintain their non-immigrant status in the United States even if they also had the intention of immigrating to the United States permanently. Since the Supreme Court's decision in matter of form Hortan, there have been a number of court cases involving dual intent. In general, the courts have held that non-immigrants can have dual intent, but that U.S. consular officers and immigration officers have the discretion to deny visa applications or requests for extensions of stay to non-immigrants who they believe have dual intent. Here are some examples of court cases involving dual intent. In the 1980s, the Supreme Court of the United States ruled in the case of Ins v. Fumpatia that non-immigrants who had dual intent were not automatically ineligible for adjustment of status to permanent residency. In the 1990s, the U.S. Court of Appeals for the Ninth Circuit ruled in the case of matter of Patel that non-immigrants who had dual intent were not automatically ineligible for H1B visas. In the 2000s, the U.S. Court of Appeals for the District of Columbia Circuit ruled in the case of American Immigration Lawyers Association v. U.S. Department of State that non-immigrants who had dual intent were not automatically ineligible for K-1 visas. The doctrine of dual intent is not absolute. U.S. consular officers and immigration officers still have the discretion to deny visa applications or requests for extensions of stay to non-immigrants who they believe have dual intent. However, the doctrine of dual intent does give non-immigrants more flexibility in planning their immigration to the United States.